Dan, amendment?
I want to make another amendment, so I'm not right now for this amendment on the floor.
What is your amendment?
I'd like to talk to the attorney first. Here's the thing, that I believe that the restricting the corporation to commercial leasing would affect the ability of the legal team to go in and get more money from Green Bay. So that's the question that I want to ask.
Can somebody provide an answer, please?
I think I'm probably the one to answer that question. If you can, everybody hear me okay? My name's Joe Nix. I'm with the Godfrey Kahn law firm. We've been involved on your behalf since 2011. We're the ones who took the case to the Court of Appeals, the Supreme Court, got the decision, basically saying you're right and the city was wrong. With respect to your question, I think we're a little bit on uncharted territory from the standpoint of the viability of the lawsuit. My chief concern would be the dissolution in a complete way of the Seven Generations Corporation. In that situation, we'd all be on kind of uncharted territory with respect to what that might mean with respect to continuation of the lawsuit against the city. If the corporation survives, even if its operations are limited as proposed, I would be confident that that would not affect the vitality of the lawsuit against the city.
Okay. Here's what I'm thinking. Now, this is the hypothetical motion here. Motion that the restriction to the corporate leasing proceed after the Green Bay Renewable Energy Court action becomes final. So what I'm suggesting is that we don't go into that we kind of delay the restriction of the corporation to go to commercial leasing until after the court action becomes final. In other words, that Seven Gens will go back the way it was, court action becomes final, we receive the money from Green Bay, and right after that, then they go, that it would be restricted to the corporation and commercial leasing.
Yeah, actually, I appreciate the thought there, but there's probably an easier approach to that with respect to the amendment. You'd probably, an amendment that simply clarified that the Seven Generations could continue making a claim in litigation against the city of Green Bay would probably be a more positive way to state it than the way you just phrased the possible amendment. Sorry.
No, that's okay. So,
Okay.
Dan, what is your preference, I guess? What is your amendment?
Well, my preference is for us to go into Green Bay and get the money that we deserve because all of this started because of the fact that, Green Bay removed their conditional use permit. So if that hadn't been done, we wouldn't be talking about this right now because we most likely would never have dissolved Seven Gens to begin with. But that's my opinion. So right now I'm trying to figure out a way that we can go into Green Bay and get as much money back because I think that they're the ones that are liable for what we see here and all the losses that we've taken on. I blame Green Bay for that, not necessarily GTC. Even we made maybe bad a decision, I don't know, but that's not the point anymore. So I'm trying to figure out a way to get us more money at Green Bay.
So is this your amendment or not? That the restrictions to the corporation leasing activities of Seven Gens occur after the litigation with the city of Green Bay is complete? Or allow Seven Gens Corporation to continue litigation with the city?
To the corporation activities occur after litigation. I would say instead of complete, I would say final because complete is arbitrary, final is final.
So your preference is
Okay,
the first verbiage and not the second?
I agree what's on the screen, so we'll go with that.
Well, there are two options, so which of the option, the first or the second?
Can we take the or out, put and?
If I can speak to that, I mean, my preference as being the lawyer pursuing this, I'd prefer the second option after the or.
Then let's remove the first option, and we'll make it to allow a 7 Generations Corporation to continue litigation with City of Green Bay.
Okay.
Thank you.
Second.
Who was the seconder? Cheryl. So there's a second amendment proposed by Dan Hawk and seconded by Cheryl Benton to allow the Oneida 7 Generations Corporation to continue the litigation with the City of Green Bay.
Call for the question.
You know what? It's not okay to shout out, and if you're following along, you would know that the main motion is to rescind the dissolution, therefore the dissolution did not occur, or we wouldn't have the motion. So the amendment is to allow 7 Gens to continue with the litigation with the City of Green Bay.